12:01, let's get started. We'll jump right into it. And let me tell you a little bit about Dr. Goldhaber. I've known him for about 10 years now. Dr. Goldhaber is president and CEO of Goldhaber Research Associates, LLC. And over the past, and this number may have changed, Jerry, over the past 38 years, you've emerged as one of the nation's leading safety and warning communications
41.
experts. 41. And you've been retained in over 200 lawsuits dealing with the issue of warnings and written numerous research articles on the subject of effective warning labels. Many of your clients include Fortune 500 companies and some of the top law firms in the country. So what did I miss, Jerry? Anything that I missed there?
How about my new book?
There's a new book coming out. Tell us about the new book real quick.
Next January, you'll be able to buy Murder Incorporated, How Unregulated Industry Kills or Injures Thousands of Americans Every Year, and What You Can Do About It.
Outstanding. I look forward to that. Excellent. And today we're talking about, closer to the evening on your end, we're talking about what an expert should look for in a client. What are those things that help them identify the right client? How do they find the best clients? And you've written a couple of articles on this in the past. I was reviewing one of them this morning. You've got about 5 or 6 items that really identify. And I just want to remind everybody, we're going to be conversational here. So over in the chat, if you have some questions that pop up while we're talking, make sure to ask them and we'll try and get to those questions. I'll try and ask them of Jerry while we're talking without ruining his presentation.
I appreciate it, Nick. And hello out there in Experts.com land. I appreciate the opportunity to share with you over 41 years now experience. I've learned that when lawyers ask the question, or judges, what they look for in an expert, I decided we ought to flip that and say, what should experts look for in lawyers? And even if you're starting a new practice, you've only been doing this for a year or two, or you're working with Experts.com or somebody else, I believe that you should keep in mind some critical questions to differentiate between law firms you want to work for and law firms you may have second thoughts about, and have those thoughts right at the beginning, and you'll save a lot of aggravation. So here goes. First and foremost, you want to know what is their objective for you. What are their actual objectives? What is their timeline? The first thing I say to a lawyer when they call me on the phone after I ask the question, how did you hear about me? Which gives you some marketing information. Then the next thing I say is, what's the caption of the case? Now, sometimes they haven't filed the case. That's great news. The earlier you're retained, the more value you can bring to your client. If they have already filed the case, I ask them, what's the caption? And that means tell me who the plaintiff is, who the injured party is, and who is and are the defendants, what are their law firms, and why do I stop them? Right there, I want to do a conflict of interest check. Am I already retained on the other side? Is there a business conflict? Maybe I've done a lot of work for the law firm on the plaintiff's side over the years, and I don't want to now all of a sudden go against them. That's a business decision. It's not necessarily ethics. It's a business decision that might create a conflict for you. So I want to know that. I want to conduct a conflicts check before I hear anything. Then after that, I want to know what's the timeline. This is almost a vitally important question to ask right up front, because that'll tell you how serious this law firm is. Now, if they're going to tell me, look, I want you as a rebuttal witness, I'm going to say, call Nick Rashane. I understand he's not doing so much today. If they're calling me, and if they tell me, well, Doc, we're really up against a bind, I don't even want to know what the trial date is at that point. Or they may say that there's a disclosure deadline for experts coming up in the next 3 weeks. Oh, no. Even if you're just starting out and you say, I've got to get some business, think twice, because if they're going to dump a document at you in 3 weeks, you're going to be running around and you're not going to do as thorough a job. It's more important to have quality in the work you do than to accept business just because you're hungry. So what I do is I want to know, when is the expert disclosure deadline? I want to be sure that I've got at least a couple of months or more, hopefully, where I can do a thorough job in reviewing the materials. And I don't want to be called in as a rebuttal witness at the last minute, because that's helter-skelter time. I just don't want to operate that way. And I advise younger experts also to take that into consideration. The next question I want to ask is, they're going to ask you, hopefully, what your fee structure is. And we're not in a Moroccan bazaar, and this is by no means to reflect negatively on Moroccan bazaars. We've had a lot of fun there. But we're not trying to be in a negotiating status where, you know, you're in a tailor's office, getting a new suit, and the tailor said, well, so we pull it in, push it out. You've got a rate structure, stick to it. Surveys have been done that tell us what the average rates are and where if you're comfortable charging by the hour, or if you have flat rates for depositions or trial. But you got to get the business side of it up front, out of the way. And if you hear somebody say to you right up at the beginning, I'm sorry, can you negotiate? I operate on a business model that is evergreen. A former state Supreme Court judge in New York suggested it, and I've adopted it for over 3 decades. Evergreen means you're the banker for your client rather than the other way around. That means I operate on a retainer. Your retainer can be based on whatever your hourly is times maybe an estimate on how much it'll take to go through a bunch of materials. But come up with a legitimate retainer, whether it's 5,000, 6,000, 3,000, 10,000. Some guys have 20,000. I know a woman psychiatrist who had 25,000. It depends on the kind of work you're doing. The retainer has to be paid before you look at any of the materials, because you're not officially retained. And one side trick to this is, if you're going to list your resume online, make sure you have a watermark on it that says, not for use unless retained, because it's been known, it's happened to me, it happened to you. Sometimes lawyers will retain you without even calling you, and simply put your name and download your resume and hope to get a quick settlement before you or the other side finds out. I'm not saying that a lot of lawyers do that, but some have done it.
It does happen. I do want to stand in there real quick, Jerry. It does happen. It happened a lot during the downturn and the recession. There was a much bigger use of that, and so we do recommend you put in anytime, even if you send it out to the lawyer, you should have your watermark on it until you get that retainer check and deposit it.
There are more stories we could share with you. I'll give you one quick one. During the Fen litigation, I won't even tell you if it was on the plaintiff side or the defense side, I was retained. They sent me my retainer check, which happens to be $10,000, and they sent me that check, and I never heard from them again. We tried to reach the law firm. I won't tell you if it's plaintiff or defense. We tried to reach them on and on and on. And then it turns out I was having a casual conversation with a colleague of mine, a very good friend who does the same thing I do. And lo and behold, he told me the same story. It turned out we did a few more phone calls. 4 of us who did the same thing were retained by this very same law firm just to get us out of the market. Yep. These things sometimes happen. Yep. So then you have to decide, do you want to return the retainer or not? Do you have a non-refundable retainer or a refundable retainer? But law firms have been known to take experts down, take them out of the market by buying them. So also be careful. All right, so that's the first thing you want to do, is get a clear understanding of what the assignment is, explain very clearly what the business end is, and find out if the lawyer accepts that, and then follow it up immediately with a retainer agreement that puts all of this in writing. If a lawyer is going to start negotiating with you up front about your retainer or about your hourly, you know you're going to have trouble getting paid by that lawyer. So back off. That's an immediate red light, not even a yellow light. It's a red light. Now, let's say you're retained. Everything's going well. You're retained. I have a list of materials that I have standardized over the years, give or take one small document here or there in a particularly unique case. This generally holds true. I tell the lawyer up front, here's what I like to review, because I've got phase 1 document review, prepare a report or offer an affidavit with my preliminary opinions. Phase 2, get ready for a deposition. Phase 3, get ready for a trial. Phase 1 in document review, and as we know, most of us don't get into we very rarely get to phase 3, the trial, of over 95%, at least on the products liability side, settled. So we end up with giving a deposition if we're getting that far into phase 2. Most cases, you end up giving an affidavit, or you give a federal report, a Rule 26 report, and you're out of the game at that point. So what I suggest is you ask for the complaint, relevant interrogatory discovery materials with the attachments. I recommend you tell the lawyer you want to look at all the fact or liability and liability depositions with exhibits. I'm old school. I like to read the document on the left, and I like to look at the exhibits in real time, flipping through. So make sure you get the exhibits. And then I want to look at photographs. I want to look at expert reports and so on. These are the basic materials I look at. If there's a site visitation, that's not like a lot of swimming pool cases I have. I want to look at the pool. I want to see what the signage is. I'm a warnings expert, so I'm interested in looking at signage. And I want to lay out for the attorney up front what I need. If the lawyer says, well, how much is this all going to cost? As an expert, you should tell the lawyer, look, I'll give you an estimate. I won't spend a nickel of your money. Send me the materials I'm requesting, and don't hold back. This is very important. You're the barber. You're the taxi driver. You're the therapist. You're the person they can tell everything to. Make sure you ask. I had a case, a friend of mine, I ended up doing a lot of Jeep rollover cases in defense of Jeep years ago. And the reason I got the litigation was my buddy resigned. Why did he resign? Because William Renneker, the famous Renneker memo that was published in the Wall Street Journal, said, and he was the head of engineering who designed Jeeps for Jeep. And he said, you know, some cars do this, some do that, Jeeps roll. I think Iacocca, who was running Chrysler at the time, sent him to Siberia after that memo came out. Well, engineers keep everything, Nick. They're pack rats. And that memo came out. Well, guess what? My buddy, the late Don Porterfield, who was a terrific expert, just thorough as they come, and I credit him with actually getting me interested in this field. And Don Porterfield calls me up and he says, those SOBs, they never gave me the Renneker memo. And there he was on the stand, and they asked him, have you seen this? And he was about to defend Jeep on not knowing that this hasn't existed. And there was the head guy who had designed the thing saying, whoops. So make sure, use the Renneker memo as a classic example. Make sure you ask for all the bad documents as well as the good documents, because the last thing you want is to be surprised in trial.
And one thing to add there, let me give you a chance to take a breath as well, Jerry. You're doing great. One thing I was reading one of the articles that you had where you were interviewed discussing this issue about withholding bad information, and you may be getting into that a little bit more, but you also don't want the attorney's summary, right? The really, this is the summary of the good parts of my case. Just look at and only look at these documents, because then you can be hammered later on if you've missed some of the bad information, correct?
This is the most embarrassing thing. Another one of my friends, seems like all my friends are dead. The late Ken Lockery, who was just a magnificent expert witness. I've known Ken decades, and he passed away very recently. He was a plaintiff's expert for the most part. Occasionally we worked together on defense cases. I was on the opposite side with Ken, who was the president of the American Psychological Association at one point, and he had just preceded me at Purdue University, at SUNY Buffalo. He became the head of the SUNY Buffalo Psychology Department, and I came in as the head of the Communication Department. We just missed each other, but we stayed in touch. So anyway, Ken was in the latex glove litigation on the plaintiff side, and he was opposite me, and I was on the defense side. And I developed this big tent strategy where I had 7 or 8 companies that made latex gloves, and I coordinated them all together because I didn't want 7 different experts who were all looking at each other. So I had one assignment representing all the cases, and I found out that no one client, no one company that made latex gloves did an adequate job of warning. But collectively, they could get away with combining all of their resources because they all sold hospitals the same thing. Every one of those companies pitched the hospital. So whether they got it all from one company or collectively from all the companies, the big umbrella worked. Ken was asked in his deposition, what would happen if you knew the A, B, C, or D occurred? His law firm that had retained him had forgotten to tell him that all these things were going on, because he was attacking only one company for having an inadequate warning system. I put them all together, and they withheld that vital information from Ken, and he called me up after. He says, Jerry, I don't believe they held all this stuff back from me. And he left them in a fit of anger. Make sure this doesn't happen to you. Make sure this doesn't happen to you. You want all the information. You do not want a law firm to summarize. You have a paralegal, and they're great people. Terrific. They're the sergeants. They do the work. But you don't want them summarizing a deposition and sending you the summarized notes. You're an expert. You see things. Sounds like a Bruce Willis comment. I see things that others don't see. I do read the depositions. I take careful notes. By the way, this is a personal preference. I want a hard copy. I am older than dirt. I'll agree with you on that one. But I happen to operate best if I'm not looking at computer screens. Nick, you're wonderful. I like looking at you, but I don't want to look at you all day. My eyes will be dirty, and I think I'd rather have hard copy. That's personal preference.
But that's a business decision, right? I mean, you can just say, please send me hard copies. That's what I prefer. And we did have a question here from Jim, who asked, he says he's new to expert witness work. This is in regards to conflicts. Are you required to give the reason to the attorney for the conflict if you're conflicted out? And Jim, no.
No.
You don't have to give any reason. And he also said if he didn't want to take the case for some reason, can he just say, I have a conflict? Jim, you don't have to. This is your business. If you don't want the case, you just don't accept a case.
Simple as that. I had a lawyer call me up, a plaintiff's lawyer, and he had 100 cases. I had to send my next great-great-great-grandchildren to Harvard with this, all involving motorcycle kickback stuff. And I never rode a motorcycle, but I had a bicycle and still do. And I couldn't understand why a motorcyclist wouldn't get it, that the kickstand is down and they might, have trouble if they go riding off with the kickstand. So I said, let's do a national survey and find out if the motorcyclists actually are aware of this and what they would do. He didn't want to do that. So I said, I don't think you want to do this litigation if you don't have the answer to that question, because if you've got awareness of a hazard, why are you going to sue the manufacturers if your very clients are already aware of it, especially on a failure to warn claim? So he wouldn't back down. He said, I don't really, forced him. He actually said, I don't really want to know the answer to that survey. And I said, you know what? Nick's available. Would you call him up at Experts.com? Some experts that'll be dying to take that case.
Excellent. Thanks. I'm sorry to interrupt, but I thought that was relevant to the conflict issue there. So I'll let you go.
Very good question that you were asked. Well, anyway, back on the general theme. The general theme is, folks, you're the expert. You act like an expert. Insist that your law firm client treat you as the expert. You know what you need to know. It's the reverse of Yogi Berra, who said, hey, I don't know what I don't know. You know what you know. And so therefore, you know what you need, and your value goes up exponentially the earlier you're retained in the case, because at that point, you can help guide the lawyer to ask the right questions in depositions of corporate representatives or plaintiffs that would be helpful to you in yielding information that you know you need in developing an opinion. So the earlier the better, but never relinquish your role as the expert. Doesn't mean getting into a conflict with your client. It just means very professionally saying, here are the kinds of documents I need. Here's the kinds of things I review. And I don't want summaries because, again, you're paying me the big bucks so that I and my brain can read the documents and decipher things and see things that your law firm is not able to. Because if they could do this, they wouldn't need you. They don't need an expert. There's one caveat, by the way, and what I said about getting in early. A lot of law firms on the defense side are being asked by the insurance companies to bid out the business regionally. And that puts pressure on, because the law firm has to come up with a sum of money based on the last 1 to 5 years of experience the corporations had with litigation. So experts very often are not brought in until late in the game, getting close to trial. The reason is that the budgets that they've submitted as a law firm bidding for the business excludes a month before trial. Because even the corporations are realizing that, if you actually are going to trial, it's all hands on deck. That puts a lot of pressure on the expert. You may want to think twice, as I said earlier. Do you really want to be in that pressure cooker? Now, another rule I have, and this gets to questions you want to ask, a tip for determining if you want to work for a client, is we talked about not wanting surprises. You can tell by the questions you ask if the lawyer is going to be comfortable. Sure, they might say to you, well, I don't know if this kind of document is relevant. I listen to the language they use. I say, well, Doc, I don't know that you need to go through all of the fact witnesses. They're all going to say the same thing. Be careful. That's a clue that he's trying to limit you. Now, from his perspective or her perspective, they're looking at dollars and cents, and I expect that's a legitimate concern. You as an expert should be able to give bids out based on the documents that are sent to you. And, there's an old saying in my field, information by the pound. That's how much it'll cost. Well, this is not a delicatessen, but if you've done this long enough, you could tell that certain types of depositions are going to take a certain amount of time. I used to do a page a minute, but I found that I could read 2 to 3 pages of some fact witnesses in a minute, and I would have to read an expert's deposition. Maybe it would take me a couple of 3 minutes a page because I really want to focus. Maybe I want to reread that expert. I take notes and then I want to go over it again. So some depositions take longer, some take less. But you ought to be able to make estimates of your time and give it to the law firm so that they have a ballpark. This isn't an engineering contract where your estimates have to be within plus or minus a few bucks. But you ought to know after a few years of doing this roughly how much time it's going to take you. And it's not unfair for a client to say to you, can you give me an estimate to get the report done? Can you give me an estimate from the time of the report for the deposition and from the time of the deposition of the trial? That's very reasonable.
Right.
As experts, we should be able to, that's not something you want to fire a client for asking you. That's legitimate. What you want to be careful about are clients that start negotiating with you at every step of the way, or who don't want to pay you a retainer, or want to get you to lower the retainer, or who want, because later on you might get surprises from people that say, hey, that bill is way too high. You should never get that response because you should be communicating with the law firm every step of the way. And that means if there's a lot of, if you get the documents and you suddenly realize this is going to cost more than my retainer, you must call the lawyer that moment and say, look, my retainer is X thousands of dollars at so much an hour. I estimate this is going to take 10 more hours than I thought, and it's going to cost you this. I have not spent a nickel, but if you want me to go on, this is what it's going to cost you. You need to communicate with the lawyer. It's not fair to the lawyer to have an expert not tell the lawyer what time is involved in their review. That's perfectly legitimate.
And in that, that's a good test too, right, Jerry? That's an excellent test. If you give them an estimate and now the haggling begins, that's a real test as to, okay, well, how much, and if they think it's outrageous just on the estimate before anything started, that's a good test for you to say, all right, well, do I really want to do work with these?
That's when I say, call Nick. He's got some, just starting out. No, seriously, I got to tell you this, folks. Trust me, please. I also happen to have a group in the Northeast, mostly New York City regional experts. If any of you are out there in the New York area, you want to meet for lunch once a month, there's probably about 20 of us who get together every month for lunch. And we talk about this all the time. And we're sitting around the corner from the New York City bar, and we're active in the state bar as well. And we see these same issues come up. And this is really important, because you as an expert are not going to do a good job if back in your mind is, why am I doing this if I got to fight these guys to get me paid? And you're going to want, and you're not working for some secondhand insurance company, and you're not going to fall for the thing, well, we'll pay you when the insurance company pays us. No, your client and your retainer agreement have to say the client is the law firm that retains you. I'm not interested in how long the insurance company takes. That's their problem. Don't get me involved in your mess.
Right.
You pay me my retainer, and when the retainer starts diminishing, my office is very good. They determine if we get within a couple grand of the retainer, we re-invoice the retainer. And we have in our retention agreement a very specific clause, and it's on every invoice. At the moment that a report is due, all invoices must be current. And we hold the report back. We stamp draft on every single thing we send them until the check clears the bank for that phase of what we're doing. And just since I'm on this, we tell them that I happen to be flat rate per day on my depots.
Hmm.
They have to prepay. Whoever's paying for the depot, whichever side it is,
Sure.
I have to have a check in the bank before I'll appear. And if anybody's negotiating that, I stop work.
Hmm.
And I don't lose money because they've already paid me for the work I've done. Because remember, I'm their banker. It's all prepaid.
Right.
You've got to accept that philosophy. I cannot tell you how much aggravation you'll avoid and how many clients you'll wish you'd fired if you hadn't taken my advice, because the retention agreement in writing and a complete understanding that you're holding their money,
Hmm.
you're working off their money rather than they're working off your money. And that means by sending them an invoice after the fact, you're sitting back. And that opens you up to, look, I used to teach as a university professor. How many students' grandmothers died before the test or whose dogs ate the homework? Well, by analogy, the students got nothing. The lawyers have got nothing. There's no lawyer who wouldn't have their dog eat your invoice. And you know who tells us this? The people who are the sergeants, the paralegals, the truth sayers. These are the assistants, the secretaries, and the paralegals.
Hmm.
That invoice has been sitting on Mr. Jones's desk for about 6 weeks. After Mr. Jones said, "Can you send me that again? I don't know if I ever got that."
Right.
So you want to save all that nonsense and all the professional conflicts that come with it by doing one thing very simple. Get your retainer up front and then proceed to work.
Yeah, and that goes at every step of the matter, right? You started off retainer, then hold back the expert report until we get paid. Get everything up to date. Same thing for depot. Same thing for trial. Should it go that far?
And you're going to let your feelings get in the way.
Yeah.
You're going to say, "Well, I've worked with this client for 13 cases. I had 72 cases with one law firm, and number 73, they tried to, hey, we haven't been paid yet. Can you give us a little more?" So it doesn't matter. Withhold your emotions. You're determining whether to work for a client. It's a business arrangement. Remember that. This is a business first. You're not doing this. You feel good because you're, in my case, if I'm on a plaintiff side, you're helping out. Maybe your warnings will prevent a death or an injury. Fine, that's excellent. But in the relationship with the lawyer, which is what this Experts.com webinar is about, it's a business transaction.
Right.
And make sure it's in writing. Make sure you're the banker. Make sure that the signals that you get up front are not avoided by you because you really need that check.
And this is a great question from Kenneth here. I think we've analyzed the retainer issue pretty thoroughly. This question goes into just cost as a whole. Kenneth says he'd oftentimes like to be more thorough, but many times limited by warnings about taking too much time.
Well, you've got to know what time it takes. Now, remember, there's a check and balance on you in the law firm's office because you're not the only expert they're using who's going to look at the same materials you're looking at. Now, again, if you're an engineer, you might be doing certain tests that only you will be doing and only you know what the costs of those are. And it's certainly legitimate for a law firm to bid that out to other engineering firms and say, how much will it cost to do an accident reconstruction? How much will it cost to determine an analysis of this pool? How much will it cost to look inside of an asbestos-containing product and determine what the likelihood of the standard being exceeded? So that's legitimate. But in the case like where you're reading documents, if you've got 3 experts, I'm working on some cases now. You've got an FDA expert, you've got a pharmacological expert, you've got me as a warnings expert, you've got another expert, an MD. All 4 of us are reading the same deposition. You really, you're not going to have a lot of leeway, and you shouldn't. You should, if it's 120, 150 page deposition, you can look at how long it took to take the deposition immediately. It says it started at 9 a.m. and it ended at 12 noon. Well, it took 3 hours for them to take it. It's certainly not going to take you 3 hours to read it.
Sure.
So let's get real here. So if
Yes.
you put in, it took you 5.5 hours to read a 3-hour real-time deposition, and the other experts put down 1.75, 2.0, give or take, you're going to be the outlier, and immediately you're going to have a problem. So I know some people read slower, some people are more thorough, but we're really not talking about a lot of deviation here when you got 3 or 4 scientifically prepared, educated experts reading the same material. So be careful about that. Look at how long it took them to take it and then judge accordingly going backwards.
Excellent. Excellent. So we have some more questions, but I want to let you get through. We'll try and leave 15 minutes. We got about 15 minutes left, and then we'll do 15 minutes on questions.
Well, I think that the important thing, we've already discussed the money thing, and I really don't want to go more into it. And I've already told you the kind of tips I have, and if clients don't follow that at the beginning, you'll know it. I think that the most important thing at the end of the gig, don't forget this, you want to know how the case turned out. And how many times, we would at some point, we might be carrying 20, 30, 40 cases that are semi-active to really active. And my staff are very good at this. They keep calling the lawyers, what's the status on this? You'd be shocked to find out that some key depositions were taken and oops, you didn't get them. So, every month you should check in with every client. If you're doing it yourself, you make the call. If you've got an assistant or associates or you've got secretaries, have somebody call every month just to check on the status of the case, because certain documents may exist and you want to make sure that they haven't. And lawyers all the time, I've got one going right now. He's got 3 cases with me, and all 3 of them, hey, didn't you send Goldhaber I thought you sent the Smith deposition. Oops. And I'm asking, I don't know what I don't know. I didn't know there was a Smith deposition. So you've got to constantly check in. That's an important thing to do. And this goes right through the end of the case. I like to know how it turned out. We're not judged on a win-loss record. Law firms are, we're not. We're just experts. We give our opinion. We're not advocates. We're experts. We advocate only as far as the science lets us go. We're advocating in the sense that we're giving opinions based on science and research and data and facts. But we're not advocating for the arguments that the lawyers are making. But we'd like to know how did it turn out.
Yeah, because a lot of that information as well, Jerry, goes in your CV.
Absolutely.
So you want some information to make your CV a little bit more full and to properly represent your practice.
I'd be open to any questions as we go along.
Sure. So we have one. We had one here from Lee. He says, what provisions do you have in your contract that allow you to get out of the case, if any?
Well, first and foremost, if the client withheld and withholds and lies to you, you ought to have an ethics escape clause, because certainly they're going to have it on you. And this goes both ways. Secondly, if your work, and different experts behave differently, but on the business side, and I not only have it in my retainer agreement, but also in all our invoices, if you're not paid, you don't show up. The judge can't make you appear if you're not being paid to appear. It's a business issue about being in a deposition and having a report released. So these are the kind of things we put in our retention agreement. We put it on the invoices, and we do it orally. So the message to the lawyer comes 3 ways. This is what I'm really saying is, this is a serious business. Treat me that way, and I'll provide a professional attitude back to you. But I'm trying to help your audience, Nick. I'm trying to help them decide up front what signals they're looking for up front, so they don't even. The worst thing you want to do is get into the conflict down the road. What I hope I'm doing today, and hopefully your questions will gear towards that, is trying to help you figure out ahead of time what not to take. Remember, the question here is, what lawyers do you want and what lawyers don't you want? And sometimes you can't avoid it. They'll give you all the right signs. I was on a law firm called me up. Maybe this will help you out too.
Good.
A law firm called me up and they said, hey, we'd love you to consider a lot of cases. Be careful. The minute you hear that, This is in Vegas. They call it the if-come line. I don't go to Vegas all that often. But if you're in Vegas, you'll know what I'm talking about on the crap table. The if-come line. You know, hey, the little carrots being dangled in front of you. The minute a lawyer says, I've got a lot of cases, one says, I got 550 cases on the line here. You're going to be working for the rest of your life. Immediately, hold on to your pants, folks. Be careful of that law firm. Immediately, that's a yellow light. All right, it's not red yet, but it's yellow. And I always answer, well, let's take it one at a time, and let me hear what we got to talk about. So I'm being called by this lawyer, and I'm on my way to a vacation, and the train that I'm on, the Long Island Railroad, is going to go right by where this guy's office is. So I said, all right, you want me to stop by? I said, you can look at my website, this video, you can see what I look like and how I'll be as an expert in trial and all that stuff. But no, I want to see you face to face. Okay, fine. But just remember, this is a 15-minute courtesy call. I'm just going to talk with you about the caption. I'm just going to talk to you about Jack Webb, the facts. Give me a 2-minute summary of the case. 2 minutes. I don't want to hear any of your strategy, because what if I don't work for you? You want to tell them up front. I decide after hearing 2 minutes, I don't want this. I do not want this. It's just not going to, for whatever reason, I don't want it. If he's already gone into the strategy, you are not able to work for the other side if the other side calls you, because he's already given you some strategy. So cut that off at the pass and just simply, so I go to the guy's office on the way down to my vacation, and I stop in his office, and immediately I walked in. There's a conference table filled with about 6 feet of paper spread out. And I said to him, what's that? He said, well, we thought we'd talk you through what's in the case. I said, nah, not going to happen. I said, I don't even want to go in that room. He says, well, you know, we got a lot of cases here, Doc. We want to be sure you're the right guy. I said, look, I tell you what, I don't think you're the right law firm. That's what I actually said to him. And he got all indignant. Well, we brought you down. I said, you didn't bring me down here. I'm on my way to a vacation. I stopped as a courtesy. I'm going to have to wait another hour to get another train now. But I'll tell you what, he wanted me to go through the documents and give him an estimate. And I said, no, I'll do that after you retain me, and then I'll refund the retainer if I do not choose to come. But I want your money up front. Well, what kind of experts do that? I said, this one. And I said, you know what, this isn't really going to be good use of your time. I don't want conflict. I simply said, it's not a good use of your time, and I left. Because the lawyer was trying to get me to sit and touch the documents, to see the documents, and he would sneak in some words in between. That would conflict me out. And more importantly, he's getting me to do work before I'm retained. So whether it's on the phone or in person, the way I'm talking, you think the whole legal profession is out to get us.
Right.
Well,
no, but they're running their business as well.
They're running a business. It's not fair to criticize them for being good business people.
Right.
All I'm trying to do is sharpen our,
that's right. You're running a business as well as your expert practice. So we got a couple of other questions on this. Several. Thank you, everybody, for the questions. I'm going to try to get to them all. We probably won't have time for all of them, but we do have, if a case is settled out of court that you were the expert for, would you still put that on your vita?
If the case is settled, you may have a confidentiality agreement. So be very careful about quoting from, in this new book I had to hire a lawyer to do a legal scrub. That means he read the book, I paid him to read it, and he then protects me and the publisher from getting sued because we said things out of court. And one of his most common questions, because I wanted to make it as real as possible, use as many case examples as I could, tell stories, real stories about real cases and real people. That's what sells a good book, by the way. So the law firm said to me, be careful, Jerry, if it's a confidentiality agreement, you don't want to be talking about this either on your resume or in your book or in speeches. If you sign something that says, I won't discuss this, and they settle. Now, if it goes to trial, that's another thing. But even if you're deposed, the deposition itself, while you may say that's public, and why can't I list that I was deposed? You have to list on the federal rules the last 5 years of cases that you've testified in trial or by deposition. That you have to do, but all you have to do is list the case itself. So you certainly can list that you were retained in cases, but you can't talk about the cases.
Right. And there was another question about this one from Larry. What is your take on getting references and being allowed to disclose info on past cases? Some cases push me to have total non-disclosure. And in that case, there's not much you can do if it's a total non-disclosure.
If you get non-disclosure, then you get non-disclosure. If you want references, ask the lawyer ahead of time, can I use you as a reference? Can I have, sometimes a lawyer will volunteer. I know I just got hired in a case in Morristown, and I know immediately my office will tell me, who have we worked for in the past in Morristown? Now, what I will say to the lawyer who's calling me up from Morristown, who's deciding whether to retain me, I'll say, you know, I've done work for, now this isn't violating confidentiality. Somebody says, I've done work for Don Jones in Morristown in his law firm. Feel free to call him up if you want. I can do that with or without calling Don Jones up. I'd be smarter if I called Don Jones up first, because when the lawyer from Morristown calls me up, I'll know we have a computer database of where all of the law firms are and who we worked for and what cities and towns, what products. You know, the more years you do it, you want to organize your client base. It's great for marketing. It's also good to give references. But I'll usually ask the person ahead of time, can I use you as a reference? If you had a bad experience, be sure you know, this goes obvious, but you don't want to make sure that lawyer isn't somebody you ever have as a reference.
Yeah, it's a very good information on that. Jeff asks, and this one's a little long, Jeff, so I'm going to try to parse it down a little bit. He's been tasked with a software usability, breach of contract, no complaint filed, nothing like that. He had a presentation from the software engineers. Their attorney, who is his client, wants him to produce an expert report with his opinion, primarily for the boss or the president to decide whether or not to go ahead in litigation. And he's asking, is an expert report really proper at this moment? Wouldn't a simpler declaration be more appropriate? So that's a tough question, because he's really acting as a consulting expert at this point, not an expert witness.
That's exactly where we're going, Nick. We're on the same wavelength. Jeff, you're on as a consulting expert. In fact, most of us are consulting experts until we're not.
Right.
And that's fair. Don't be insulted by it. If from a business model, if you're the lawyer, you're not sure if you want to hire Gerald Goldhaber to go into court or to be deposed in a deposition where I might, you know, make some mistakes. Maybe they don't like the way I talk or the way I look or the way I'm arguing. Maybe they want me in the backdrop. Maybe I've got a problem in my background where I can't be useful in court, but I can be very useful in background as a consultant. So a lot of times you want to be, in this case, Jeff, you are definitely a consulting expert. And so unless they tell you you're going to be retained at some point future as a testifying expert, then the question is actually moot, isn't it? As to what, if they don't, as a consultant in many corporations, I write reports. That's what I do.
Yeah, that's what they hired you. They need the insights. And they may go with somebody else entirely different for testimony.
I mentioned Ken Lockery. He and I worked in tag team. I backgrounded on some consulting work, and then he did consulting work, and then they flipped a coin. Who they decided was available was going to go to court.
That's right. Excellent. So, folks, we got about 15 minutes left here. I'm not going to make Jerry go past 4 p.m., but we do have a few questions here. So this is a good one, and this one does come up, and you touched on it a little bit earlier, but can you work for the other side if you turn down a case or are for some reason not hired by the first side that contacted you?
Yes, you can. So go ahead.
There's a little bit more to it, but assuming you do not know any of the confidential information, just the facts.
That's right. If you don't know, all you know is the caption, and you know a couple, 3 sentences of who did what to whom and how it happened. That's fact. This happened. You can get that from a news story covering a lot of it. If it's an injury of interest to the public, you might get a local TV story or a local newspaper. That's fact. That's not about how I'm going to try the case or what's my strategy going to be or what I want you to do. And I always tell that to the lawyer up front. As long as they haven't told you their strategy, and that's their legal strategy as well as their look for strategy from an expert. What are they looking for? What kind of an opinion do they want you to come up with? That's not what's your opinion, but what is the area they're looking for? When they stay away from all that, and for whatever your reason, you decide no. And maybe the reason is you've been working for the defendant in the past, if this is a plaintiff calling you up, or if it's a defendant, you've worked for the law firm before. You don't have to disclose why you're conflicted. You simply say, no, I'm not able to take that case. Now, if the other side calls you, that doesn't, by the way, I don't know, Nick, about the ethics of this, but it's certainly unseemly. Let's put it that way. For you to say, I don't like that side. Let's say you're getting a phone call from Johnson & Johnson, and they say to you, hey, we want you to help us out with these opioid cases. All right? And you say, and you say, no, thank you. I'm just not going to be able to help you. Thanks a lot. Goodbye. It's a little unseemly if you then pick up the phone and call one of the lead counsels on the plaintiff side and say, hey, I want to work for you guys. It's not unethical in the sense of you're conflicted, but it's certainly slimy.
Yeah.
Ambulance chasing slimy.
It's probably, it's not probably unethical. I don't know that it's recommended. Chances are, if you're getting, and especially on cases the size of the national opioid litigation, if you're getting contacted by one side, there's a good chance the other side's looking at you too anyway.
Yeah.
And this is going to happen in smaller, if you're in a smaller town or even in New York, right? There's probably only a handful. So if there's a litigation taking place in New York, it's Jerry and it's Ken. Those are our two. So there's a chance you're going to get contacted by one or both.
That's probably the case. And I mentioned opioids because both sides contacted me. And I'd already decided and I was already working for it. So it was easy for me to say when one side called me, I'm sorry, I'm already conflicted by. But, you may have personal preference. Even if you're not going to work or want to work on it, you still have the right to say no. But you really don't want to engage actively, and because that could open up a potential issue. And even if you're retained and there's no legal conflict or even ethical conflict, you could get embarrassed at the deposition when all of a sudden you appear and they say, Dr. Goldhaber, we called you up. Now, even if you didn't do anything wrong, they can still make it look like you're the ambulance chaser in the room.
And they'll try, because especially if they don't have anything else with which to impeach your credibility, they'll try and finagle something like that.
It happened to me, and fortunately, and I'll share the story very quickly, in all my phone calls, I have my assistant on the line with me. I don't know why I started this practice, but from day one, Donna Patterson, she's been with me all these 40 years, God bless her. She's the best. And Donna has been on the phone with me. Every single time I will take notes, she's the one taking notes. And this law firm 5-10 years ago calls me up, and we get calls all the time. I take a few notes, she takes some notes, and if we hear from them, we hear from them, we follow up. If we don't, we don't. This is one of those we never heard from again. 4 or 5 years later, and that was the defense side. 4 or 5 years later, a plaintiff's lawyer whom I'd done a lot of work for calls me up, and he starts talking about a case, and I say, oh, that sounds like a good one, I'll take it. And I go to work for him, and I'm getting disclosed after writing a report, and then he calls me up and says, they just told me that they already had approached you on it, and they told you the whole strategy. I said, I don't know what you're talking about. I don't know who the hell these people are. And then we keep all the notes. We're the engineers of expert witnessing. We're pack rats. We keep everything. And so she went back with me. I said, let's check that out. So we went back and back and back, and we actually found the notes of the phone call. And Donna had them, and they had absolutely nothing to do except name, date, and serial number, the Jack Webb model. And all we had was the date, the caption, and what the facts were. And we produced that. And I said, could you show us any other notes you may have that are contrary to this? where I was privy to any of your conversations, because according to our notes, and by the way, my assistant was on the line, and we have a witness that says, nope, Dr. Goldhaber just went down. We have a form sheet. That's all we follow. Is here. What's the caption? Who are the law firms? When's the trial? What's the disclosure deadline? And give me a 2-sentence summary. End of story.
And I'll tell you this. I'll tell everybody this. I know that this is a practice for Dr. Goldhaber because every email I get from Jerry, Donna is CC'd. So I know that this, and we're not even in the litigation of any type, but she is involved in every step. And another thing I want to add, I think it was to Jeff's question, as far as, and it goes with the one more question that we have here, is the plaintiff and defense thing, and people from plaintiff and defense are all looking at the same experts across the board. It is, there's a limited number of visible experts. Jerry is going to run into the same expert on the opposite side multiple times, probably even friends with these people.
Sure.
We know for a fact, and one of my favorite ones is related to the opioid litigation, the national one. We know for a fact on our website, in our member reports, that Johnson & Johnson is looking at the profiles, and so is Motley Rice and the rest of the plaintiffs. They are looking, and this information is available in Jerry's profile on Experts.com for him, for all members. This is my shameless plug for you, but we know that both sides are looking, and they're looking at the exact same folks for everything. And that runs me into this other question. How do I get more? About 70% of the calls, this comes from one person, about 70% of the calls are from plaintiffs, and I often don't find in their favor. How do I get more calls from defense attorneys? This is one of those questions that it's either one or the other that people are having, everybody wants the 50-50 down the road. So how do you get more from both sides if you can?
It's a very simple thing. If you want to go pick apples, where do you go? You don't go to a peach tree, you go to apple orchards. You want peaches or oranges, you go down to Florida and go to an orange bush, orange grove. Same thing with defense. If your question now is you're doing 70% 30 and you want to get more defense work, what do defense lawyers read? Where do they congregate? What meetings do they have? The DRI, Defense Research Institute, invites me once in a while to give a speech. So you have contacts with lawyers who are active, or even those who go to the meetings, some of your clients. You can ask, I know a guy who knows a guy. Talk to lawyers and get on a program. Once you're on a program, or just go to a meeting, even if it's the local meeting. We have a group in New York called the New York City Bar Association. And they have products liability, tort litigation groups. They've got personal injury groups that reach out to plaintiffs' lawyers. And so from the titles, if you're looking, LinkedIn, if you don't want to go to meetings, if you don't want to talk to lawyers, and look, if you've got clients, ask your clients what meetings they go to and ask them if you can go with them to a lunch meeting or a dinner meeting, and find out where the national meetings are held or the regional meetings, and find out who's in charge of those. Write them a note. Say, here, I've got this expertise. And you have to have something to say. They're not going to just say, oh, great, come, you're on the program.
Right.
The idea is that you have to put yourself out there. Apples go to apple trees. And so therefore, if you want to talk to defense lawyers, find out where they are and mingle with them. Write to them. Submit articles to defense journals or defense newsletters. This is how I do it. I simply write and put my work out there. And, I've risen to where I can have a CNN platform occasionally, not as much these days. I don't have enough to say about the president one way or the other.
Right.
There, but MSNBC, we're talking to them possibly if the new book does well. So there's platforms. Yeah. But I'm
going to add to that, though, Jerry. I think you're right. I just talked about this at the FEWA, Forensic Expert Witness Association this spring. which is the one expert witness association that I go to, or the one thing that I've spoken at expert witness related. Everywhere else I've attended for experts.com is where the lawyers are at. And that's where you need to be. Fish where the fish are at.
Fish where the fish are. And I'll tell you something, it pays off. I went to the New York City Bar, the New York State Bar Association. Every year they meet in New York City at the Hilton Hotel. And I go to it just to walk around. I don't have to have a badge and pay. I just walk around. I go to the display areas where they're selling books and everybody's got, and you find people.
Yep.
You meet people.
Yep. That's how it is. And even though Jerry said, try it on LinkedIn if you don't want to meet people in person, I just have to say, I disagree. I know that is the comfortable for some people, but you got to get out there and shake some hands.
You have to. I was going to say with LinkedIn, and you took the words, sounds like Meatloaf. I just saw the concert with my son. You took the words right out of my mouth. By the way, the question I've got for your viewers is, tell me the name of Meatloaf and where he was born. Okay.
Okay. And we have one last question here before we, but it sounded like you wanted to follow up on that item about shaking hands.
Yes, you do. I was going to say that when I speak at the New York State Bar, I actually go there. They invited me for a breakfast once a year because I wrote a chapter for the New York State Products Liability Handbook on warnings and things. And so I get invited to breakfast. Well, that's at 7 in the morning and there's 10 people having breakfast. They give me a badge. I just walk around and I can go anywhere I want and I'll spend a day there. Yep, and I'm collecting cards and giving cards and just chatting. You have to do that.
Yep. That's great. And one last question here, Jerry, folks, stick around because Jerry's we'll have an answer to this one. And then I want him to tell you where we can find you. But has there been a situation where you discovered something in the middle of the case that you wished you should have inquired about early on before accepting the engagement? Something other than the items that we've mentioned.
Well, yeah. I was actually at a trial, talking about in the middle of the case. This was actually at the trial. And one of my routines when we go to trial, and again, it's 5-10% of all cases in my life have gone to trial, same as the national stats. And I always ask, tell me where the jurors are sitting, tell me their names, tell me as much as you can about their occupation, their background, because I've got a ream of examples I can use to illustrate my background. So if I know there's a nurse out there and I'm looking at Nurse Jane, I'm going to look right at her. And then the guy will say, well, Dr. Goldhaber, can you tell the jury a little about, have you ever done any studies in the healthcare industry? And I'll look right at Nurse Jane. Or maybe he won't program it that way. He'll say to me in direct, tell us about some of the sectors of society you've done studies in. And I'll go, well, I've also done healthcare studies. I've studied hospitals and how nurses and doctors have breakdowns in communication. I'm looking right at Nurse Betty, and the minute she smiles and nods her head, I got that juror. Well, using that technique, I found a person who had worked for Firestone, and I said, this is a case which involves similar issues. So I said, and you know, I've done a lot of work for Firestone, and I'm looking right at the guy, and he afterwards, the lawyers said, oops, we forgot to tell you, he got fired from Firestone. I said, that's a big oops. Well,
that's a big oops. That is a big oops. Thank you so much, Jerry, for taking the time with us today. Everybody who's here, will be sending out the replay. We'll also be making it available on our YouTube channel. Jerry, Jerry's going to have access to your email addresses and your names, so he can reach out to you. He'll probably want to know some follow-up from you and see how he did. I think he did. Looks like we're getting lots of good comments, so it sounds like it was very good. Everybody enjoyed it. Jerry, how do they find you?
Okay.
Besides experts.com, which link I've posted in posting again.
Experts.com, obviously. And by the way, I love experts.com. But let me go to my name and email. It's very simple. Gerald Goldhaber. My mother hated me, so she named me Gerald instead of Gerald. G-E-R-A-L-D, Goldhaber, no dashes and spaces. Gerald Goldhaber at yahoo.com. And I'm in New York City. If you want to call, I'll answer any of your questions that we didn't get to today. I'm listed under Goldhaber Research in New York City. On the website, we've got our numbers in Buffalo and New York. Goldhaber.com is the website. So I don't have to give you numbers. You can find me on the web, goldhaber.com. And all of our 12 years of newsletters are there every month. So you have fun.
And you can sign up for his newsletter. I get a copy of it monthly. Excellent information. Great information for warnings related and additional polling and survey data, but you'll be surprised what you can learn about the things that are going on with warnings and product life.
One more thing.
Sure.
Go Sox.
Go Sox. Okay. All right, Gerald. Thanks, Jerry. So it's weird for me I call him Jerry or Dr. Goldhaber.
No, Jerry's good. Please, Jerry.
Excellent. All right. Thanks everybody for watching, and we'll go ahead and include the replay for you soon. Thanks, Jerry. Have a good one.
You too. Thanks again.
All right. Bye-bye.